the Final Third Network. We're back with estate planning and elder law attorney Matt Margolis. Matt, thanks for cutting segment 2.
You got it.
And again, as I said before, in between every segment, we shoot the breeze a little bit and talk about things that we would have liked to have brought up in our segments, or things that we either we didn't talk about it in a segment or we wanted to. And so today we're going to talk a little bit about powers of attorney. And so I'm sure that we've all heard the little piece of pearl of wisdom is that the shoemaker's children are the worst shod. How is it that the mechanic has the ugliest, smokiest running car down the street? The shoemaker children are the ones with like no shoes.
Right.
So I'm sure in your world, Matt, you get a couple that come in, they're in their late 70s, early 80s, and you talk to them about powers of attorney, a will, trust, all those kind of things, and they got nothing. Right. They've got nothing, and they're starting out. And I know that we had the experience in our own family where, again, my dad being in his 80s, he was like the silent generation. He never shared any information with anybody. He was very tight-lipped. It was always like, I've got it taken care of. I got it taken care of. Everything's taken care of.
Right.
Well, guess what? Nothing was taken care of. And everybody turned white when we found out that my dad had nothing taken care of. So give us a little bit of a description of what a couple, or even someone who's alone, a widow or widower comes into your office, they've got nothing. Where do they begin? Let's talk a little bit about powers of attorney for healthcare and property, and we'll just go from there.
Sure. So, Bill, what you just mentioned is extremely common, right? So, I'd say my average client comes in probably somewhere between age 55 and 75, whether it's a single individual, married couple, and the vast majority of them have never done any planning. That makes sense, right? Because if we look at statistics, and I'm not going to quote any, but in general, most of the statistics you'll see out there are, say, somewhere between 65 and 75% of Americans have zero planning, right? Nothing. No powers of attorney, no will, no trust, no nothing. So it's not uncommon, even though every client comes in and says, oh, we should have been doing this, and we're probably the only ones. And of course, I try to make them feel a little bit better and say, you're not. You're in the majority.
Right.
So you're a person that's coming in for the first time with nothing, and really from a blank slate. Typically we're looking at planning, sort of two aspects of the planning. So we're looking, we're talking about wills and trusts and what makes the most sense there from a planning standpoint. And then we're talking about sort of all what we refer to as all the ancillary documents.
Ancillary, okay.
And that's going to be the healthcare power of attorney, the property power of attorney, the HIPAAs, the living wills. Clients will always bring up the DNR, which is now called a POLST.
POLST.
POLST. Right. Practitioner's order for life-sustaining treatment, which we don't handle, but they can sit down with their doctors and fill that form out. After we cover the wills and trusts, then we get into powers of attorney. But I really tell clients that, and I was just saying this to you in the break, that in every talk I give, and I do quite a bit of public speaking, I always like to spend the first 5-10 minutes talking about powers of attorney, because I think they're documents that a lot of people brush over. Mm-hmm. Because we've heard them so often. Most people don't really know what they are unless they've dealt with one at some point. And they kind of brush them aside because they're like, well, the will and the trust is really what we need to focus on.
Okay.
Well, in Illinois, we've got two powers of attorney, healthcare and property. And really, these are documents where the purpose of them is to name somebody legally to step in and make decisions for us if we get to a point where we can't. Mm-hmm. They're two separate documents. We can name a different person to make financial decisions for us, which is the property power of attorney, versus healthcare decisions, which is the healthcare power of attorney. We can name the same person if we want. But the way that each document works is we can name as many people as we want. It's one at a time in a particular order. A lot of clients have problems where they're like, my one son's going to be really disappointed if I name my other son first, and yada yada. My response is always, let me talk to your son who you're not naming, and I'll tell him that he's lucky that you're not naming him, because it's a thankless job being a power of attorney, right?
I've heard that.
If somebody becomes incapacitated and then their agent, which is the person they're naming under their power of attorney, has to step in, you're potentially doing a lot of work. You are now their person paying their bills, and you're meeting with their financial advisor, and you're doing their taxes, and you're probably dealing with issues that come up with Medicare and Social Security.
Right.
You're basically end up running another household. So, but these are important documents. If we do not have powers of attorney, mm-hmm. and we become incapacitated, we're going through a guardianship. All right, and a guardianship, you can sort of look at a guardianship like a court-appointed power of attorney. That's going to go from costing a couple $100s to a couple $1,000. And if you're a property power of attorney, you're also going to court on an annual basis, checking in and giving an accounting of how all the money was spent for that person that you're taking care of. That is not ideal.
Right.
So it's so important that people get their powers of attorney in place. One thing I hear all the time is, and this comes up, is my dad or my mom doesn't want to give up
control.
They don't want to give up control.
The big C.
They don't want to give up control. They think that they're just giving up, all their rights and all the control by signing a power of attorney, and it's really not what it is. And I actually just met with clients recently where this daughter has been trying to get her parents to sign powers of attorney for 2 years. We just finally got them signed, but it's a situation where both of them are in failing health, and we had to get doctors' letters signed saying that they had the capacity to still sign a power of attorney.
Because you have to be of sound mind and body in order to sign a legal document, and if you're entering dementia or Alzheimer's, you're not even legally allowed to sign a document, right?
With a little bit of an asterisk, right? So if it's early enough on, I've got some clients that have dementia diagnoses that are still early enough on where the doctor will still say that they have capacity to sign. But again, we're getting something in writing from the doctor saying that they have capacity. That's not a judgment call that I'm willing to make. There are attorneys out there that will do that. It's just not, we're a little more conservative in that sense. And I tell clients this is a protection for you.
Right, liability issue.
Exactly.
Well, let me ask you this. So as someone there are some people who get to see things globally in a really big picture. There's other people I tend to be more like dominoes.
Yeah.
Like before I can even think about looking at the second domino, I need to knock over the first one.
Right.
So if you could give our viewers an order of sequence, it can almost seem overwhelming, but knowing that there's other people, 65-70% of Americans don't have any documentation in place. If you could give us in sequence, preferential sequence from your perspective, what should be the first 5 things or 3 things that should be done? Don't do this until you have this. So 1, 2, 3, 4, 5. People are going to make their New Year's resolution is going to be, I'm going to get my estate planning and my financial house in order.
Right.
I'm going to start on January 15th. I'm going to end on December 15th, and in that time frame, I'm going to do.
So I would say if we're just talking about estate planning, I would typically say that a lot of this, because it takes people so long to go sit down with an attorney in general. We're typically going to do all of it at the same time. We're typically going to be putting the will or the trust and the powers of attorney. We and really, I'd say 95% of my colleagues, this work's going to be done as a package.
Okay.
So typically people are not going to come in and just say, I need powers of attorney, if they don't have the other stuff. But if they are going to do one before the other, it's going to be powers of attorney first.
Oh, power of attorney.
So they're not going to come in and put a will or trust together with no powers of attorney. If anything, we'll do the powers of attorney first. And a lot of times that might be more in a case where somebody might be starting to lose capacity. We want to make sure we get powers of attorney in place so that worst case scenario, their spouse or their adult children can actually end up doing the planning for them.
Got it.
Because with a power of attorney, you can have your agent draft your trust for you.
So if you have the power of attorney for property or healthcare already in place, then these people can be a proxy if they have the power to do the will and trust. Interesting.
So not the will. It's weird. Not the will, but the trust.
The trust. I see. That's the opposite of what Okay, that's really interesting. All right. Good.
But to me, this all kind of goes. The gist of it is that I'd say most people will get their financial house in order first. So it's super common for me to get clients. A lot of my clients come from financial advisors, and the reason is typically their first thought is we got to get our finances in order, right?
Sure.
People have been doing it themselves, or they've just retired. They're rolling over a 401k to an IRA. They're sitting down with a financial advisor. And typically now they feel good about getting all their financials in order,
Sure.
and then they're sort of being recommended to me or another estate planning attorney, because now it's time to get our will or trust or powers of attorney together.
I can confirm that because in my own situation as a state registered investment advisory firm, we have typically the widow will contact us after her husband passed away. They have an inherited IRA, her own IRAs, 401ks, and savings. And you have to let the dust settle a little bit, 3, 4, 5 years. And then it's time for me to do my estate planning, and I need to speak with an estate attorney. How do I move forward with that? And I've got 5 sons or 3 sons and 2 daughters or whatever, and I want to be able to begin naming them and the power of attorney, but I don't want to leave one son out, leave the other person out. I don't want them to feel bad, but that's really interesting. Okay, so then again, most of your referrals come from advisors. and you do everything in one fell swoop. So
Typically, yeah.
but it's not like you're ordering dinner. I mean, it's not like people come into your office and it's done in 2 hours.
No.
This is a lot of prep work that should be done ahead of time.
Yeah, I mean, it's a process, right? So, I mean, typically, most people really don't have an idea about the difference between a will and a trust, right? And that's the big piece, right? Because no matter what kind of planning we're doing, whether we're doing a will-based plan or a trust-based plan, the powers of attorney are going to be part of that plan.
Okay.
So, but I think the question that most people have is, what makes more sense? Most of us are familiar with this concept of a will, because throughout our lives, people have said, "Oh, you need to have a will," right? Especially for young couples that are having kids, got to have a will. Need to name guardians in case something happens to the two of you, and that's great. The reality is that we're in a day and age where a revocable trust makes more sense for a lot of people, just from the standpoint of avoiding probate when we pass away. But really, that first meeting is educational, at least in my office, and it's really educating clients on what a will does and how it works and how a trust works and how these powers of attorney work and how they all work together, and all the different people that we have to start thinking about that are going to be involved in this planning. People that are going to be taking, having responsible roles where they might have to step in and handle things for us when we become incapacitated, to the point of who's getting our stuff when we die and how are they getting it?
Right.
And then who's getting it if they don't survive us? I mean, so that first meeting's really, clients always like to start saying like, "Oh, I want so and so as my executor," and I'm like, no.
Right.
We're not talking about that today.
Sure.
Today is just big picture. From there, we start to work, through a couple meetings and some homework, I'll call it, for my clients. We get to the point of being able to put the documents together and signing them.
So we've talked about children as power of attorney, but what about those people who are single? They've never been married. They're 65, 75 years old, so they've never been married. They have no kids, no husband. They're renting an apartment. All they have is like a 401k and maybe an IRA and a small amount of assets, like maybe an automobile and a few things. Do these people need to have a will if they have one person, like maybe it's a niece or nephew, as the beneficiary to their IRA or 401k? Do these people need wills?
So I would probably argue that they should still have a will.
Okay.
Do they need a trust? Probably not. They don't own any real estate. They've got, let's say, a bank account with that gets their income, and they pay their expenses every month. And really, their accounts are 401k or IRA, which have beneficiaries. I still like the idea of a will. I still think people's wishes should be memorialized, because you know what? There could always be something else that's out there that they're not aware of. Something could fall through the cracks. If nothing else, it's a place to say where they want all their personal property to go,
I like
clothing,
that.
furniture, things like that.
Okay.
So we should at least have a will. I'd say the bigger issue that comes up with these types of people is, who do they name as their powers of attorney? I kind of refer to these people as, we do it as senior orphans.
Senior orphans. Wow, I've never heard that term before. Senior orphans. I like that.
Right, so an older individual that, like you said, it's like what you described, no family, nobody out there. And the problem is they don't have anybody that's close to them that they really feel comfortable naming as a power of attorney. I literally was talking to a woman on my drive here today, she lives in Florida, her friend lives here. She was referred to me by a care manager, and her friend that lives here has decided she's got some family, but she doesn't want to name any of them as her powers of attorney. And so the conversation we were having are there powers of attorney for hire out there? And there are. So, I have made these recommendations to clients of mine over the years where typically for them it's they don't have anybody,
sure,
but sometimes it's also we don't have anybody that we can trust.
Wow.
Right? And so there are companies and there's individuals out there where, my clients can name that person or that company to be their property power of attorney.
And what is the name of that person? What's their official title? Is it a...
Some of them are care managers, some of them are geriatric care managers that will allow themselves to be named as healthcare powers of attorney.
Okay.
Typically, they're only going to be doing healthcare.
Okay.
They won't want to deal with the financial piece. There are some daily money managers out there that will take on the financial power of attorney role.
We've interviewed one of them on this particular show, and they're wonderful. Awesome.
It's a great service. A lot of people don't know that it exists, but so daily money managers sometimes, and then there's also there's an attorney I know, former attorney, and really now as his main job is he acts as guardian and power of attorney for individuals.
Okay, interesting.
And then there's some companies out there, and I actually like the idea of companies because there's a little more longevity.
Sure.
If I name a 60-year-old professional as my power of attorney, and I'm 60, is that person going to still want to be doing it when they're 80?
Exactly.
And I'm 80, so.
I get that. Interesting. All right. Well, Matt, thanks again for sitting down with us on the Final Third Network and exploring these ideas of power of attorney and the will issue. I think it's really interesting. The senior orphans, that term, and I can see how that is in some way probably the greatest, not the greatest, but much larger demographic now than it's ever been in the time of our history. And so, Matt, tell the viewers, please, how they can get in touch with you.
Yeah, so again, my firm is Margolis Weldon. We're in downtown Park Ridge. We've got a great website, margolisweldon.com. You can reach me at matt@margolisweldon.com. That's my email, MATT. And my phone number is 847-457-3377, extension 2.
Great. Matt, thank you so much for spending and taking